SJC-12868, Commonwealth v. Edward Long.
Mr. Warren, good morning.
Good morning, Chief Justice, and may it please the court. John Warren on behalf of Edward Long, who is present today. I'm asking that this court reverse the motion judge's order for two reasons. First, because under Commonwealth v. Laura, the defendant met his initial burden under the framework, which the Commonwealth failed to rebut. And second, because the Commonwealth failed to meet its burden that the impoundment of the vehicle was reasonably necessary under these circumstances, and that the inventory search was for non-investigatory purposes. If I could begin with the Laura issue, there is a persistent and pervasive problem, which is that not everyone's treated equally on the road. And our constitutional principles do not tolerate that. In Laura, this court sought to alleviate those concerns by establishing a practical framework, not just one that could nominally allow a defendant to make a claim, but one that actually, in fact, could allow a defendant to make a claim, and a successful claim at that. And that's what we did in this case. In this case, we used relevant and available stop data. We used an appropriate benchmark with which to view that stop data, which actually was an overestimate of the likely motorists that these officers would have encountered on the roadway. And the data revealed racial disparities that were statistically significant. What happened here was the motion judge set the bar too high. And I think one way of looking at this case is to look at it in light of Commonwealth versus Laura, the facts of that case. In that case, as a benchmark with which to view the citations, the defendant used essentially the census data of a small town, the town of Auburn, to determine who the motorists would have been on an interstate highway heading into Worcester.
So Laura, it's too small. In Chavez, it's the whole state. But here you use the sense for your benchmark, which I think comes out to something like 44%. You're going through the neighborhoods involved and 6 blocks per square feet, and you indicate that that's a good benchmark. And I didn't really understand what Judge Layton's criticism of the benchmark issue was.
To your point, I think it is a good benchmark, because what we did here is the statistician looked at every FIO that these officers made over a 6-year period, and from that established, well, we know where they patrol because we know where they're making FIOs, and then very specifically looked at who lives in these exact areas and what the population was of that patrol area. And then from there, looked, well, what does the population look 300 feet, 600 feet, 1,000 feet, 5 miles, 10, out to 30 miles. And in this particular case, what happened was the areas were less black, and less black. And so when we use that 44%, that's an appropriate benchmark because it almost certainly was an overestimate of who these officers would have encountered on the roadway.
Well, did Judge Layton have that if you go out farther and farther, that the numbers don't change that much? Did he have that before him?
He did have that, and it was in Professor Fowler's report, which was provided to the court in the Commonwealth 5 months prior to the hearing. And in her report, she indicated what would happen 300 feet, 600 feet, 1,000 feet, and up to 10 miles. And then at the hearing, there was some dispute about whether the court could consider, essentially the defendant, we provided maps and graphs regarding up to 30 miles, but the court did hear testimony on that from Dr. Fowler. So in essence, the answer is yes. The court did hear up to 30 miles what the racial demographics were. And that strongly supports Dr. Fowler's testimony, which was that 44% is more than appropriate because it's an overestimate of who these officers actually would have seen on the roadway.
This is all assuming that the lower framework makes sense, right?
Right.
What if it doesn't?
So Laura was a step in the right direction. And I think the issue with Laura is that it needs to be analyzed appropriately. And there is some wisdom in Laura, because what it does is it puts the initial burden on the defendant to come forward with relevant stop data, and then it shifts the burden to the Commonwealth to explain any disparities in that data.
What do we do about the data not really being compiled appropriately?
Appropriately in terms of the
Or at all in some instances? What do we do about this?
that's the problem. I think whatever this court does going forward, it needs to incentivize law enforcement to track all of their traffic stops, because this is a systemic problem, it's a pervasive problem, and it's one in which law enforcement alone must fix.
How do you incentivize law enforcement to do something like that? How would we do that? How would,
One way is reversing the order in this case and holding that a defendant can meet his burden by putting forth the available data, the data that's available. And this is why that could incentivize, is because if this court holds that a defendant could put forth relevant and available data, and that's enough to make a defendant's claim, it would behoove law enforcement to start tracking all of their stops.
Well, in fact, one of the criticisms that the judge had of the data was that it didn't include all the traffic stops. So what you're
Right.
saying, if we say if a case is made based upon available data, the incentive is to include all data for a more realistic picture of the traffic stop.
Well, the data is evidently non-existent at this point. So what I'm saying is, if a defendant could use available data and that shows racial disparities, it then shifts the burden to the Commonwealth to explain that, Commonwealth and law enforcement. And if law enforcement is saying, look, you're using the wrong things, FIOs, citations, this is not what you should be looking at, then come forward with the total stops and show us why Officers Rodriguez and Lopes were not disproportionately pulling over black drivers. Because if they had that data, it might be a very easy hearing, and there might not really be much of an argument. And the reason that's important is because that will illuminate the problem. It really will. And it will illuminate the scope of the problem. And from there, the problem can be fixed.
If this case were heard today, what data would be available to you for the city of Boston?
It sounds like, so in terms of FIOs,
Would you still have the FIOs which identify race?
they do.
They do, so they still do that.
They still do that, although in terms of the news articles, they're no longer publicly making it available. Part of what I did here was partially rely on publicly available FIOs and then make a discovery request and gain some FIOs that were not publicly available to use in my data. I would imagine that they're still keeping track of FIOs, and through a discovery request, a defendant could obtain that. Now, with respect to citations, my understanding, based on the new law, is that a defendant could no longer obtain officer-specific citation data, because that has been made unavailable in the change of the law.
So if you were to do this today, you would not be able to present your second category of data, which is the disparity in terms of the issuance of citations.
No, I suppose I could historically, if I'm looking like I did here, 7 years back at citation data. But to put it another way, 7 years down the line, no, one could not look back 7 years under the current state of the law. And that would render the Laura framework unworkable.
On the Laura framework, can I ask you about the second stage? Because it doesn't really get discussed all that much, and I want to get your take on it. It just basically says, well, because we've never gotten past the stage one, right? So if the defendant satisfies and makes his prima facie case, the burden then shifts to the government to rebut that inference that the stop's predicated on impermissible grounds, here, race. One way to do it, and I think you argue, is for the government to show the statistics were flawed, right?
Right.
That's, I guess, easy. Secondly, well, not easy to do, but that's one way to attack it. but the second ground that I want your take on, is it possible to rebut that first stage inference with other evidence beyond just a mere denial by the police that they didn't do it for impermissible grounds?
Your Honor, so I don't think it's sufficient to introduce evidence regarding the particular stop. I think
Okay, that's what I'm asking, yeah.
No, I don't think that's sufficient.
So what if the evidence is that we stopped the car because we had a bolo that this red Audi was involved in an armed robbery?
No, I don't think. What the law framework did is put the initial burden on the defendant to set forth statistics and to make his prima facie case using statistics. And for rebuttal, that's what the Commonwealth has to rebut.
The Commonwealth takes a different view.
Okay, if I could just finish one follow-up, please. So the police officers testify that there was a car that sped by at 90 miles an hour in a 30-mile zone. We couldn't even see inside the car. It went by in a blur. Is that admissible to rebut it?
I don't think it would be a good rule to say that an officer can come in and testify, I didn't see the race of the driver. If it was a case, which is not this case, if it were a case where it would have been impossible for an officer to have seen who was in the car, I think the Commonwealth would have a good argument on that point.
Thank you.
So under your theory, if we had perfect data and we had a record of racial disparity, police officer could never successfully or could stop an African American, but it would always be suppressed because you could never offer evidence of the reason why that particular officer made that stop.
Right, I mean, I think it would need a change in behavior. And the Commonwealth coming forward, let's say the next law motion happens a year down the line, the Commonwealth coming forward and say, look, here's what's been happening in that year. There has been a change.
But you understand the problem. I mean, Justice Gaziano gave an example, armed robbery or shooting, bolo with respect to a particular car, even a particular license, or at least a few numbers of the license, everything matches. That stop would be suppressed because there's a history of essentially stop and frisk of motor vehicles which are discriminatory against African Americans?
So I think there's a different issue because I guess it would. I would suggest it
So
would.
are you limiting this to only to motor vehicle stops? Is that what you're limiting it to, or are you limiting it to all stops? Or you're saying it applies to all stops?
The law framework was limited to motor vehicle stops. I think the framework could be used in other contexts, though.
But let's just think about that answer for a moment, because I may have this wrong, but what you're talking about are pretext stops based on motor vehicle violations. Now, if there's reasonable and articulable suspicion or probable cause, you're not saying that there'd be a seizure, right? Right? Isn't that
That's
really
exactly
the
right, and I
answer?
apologize, and if I could amend my answer.
Yeah, can I ask you, that's right though, isn't it?
It is right, and if I could amend the answer and say, what we're not dealing with are reasonable suspicion of criminality, probable cause. We're dealing in this medium of there's no reasonable suspicion, and yet the car is being stopped for a minor motor vehicle infraction. So I apologize for that.
Would you ever need statistics of how many motor vehicles that had minor motor vehicle infractions apparent that they did not stop?
I think the Commonwealth's brief addresses that nicely to say that's very difficult to obtain.
Right.
Can I ask about so this is a gang unit, and I find your argument persuasive on the first prong, that the statistics here are concerning, and then I'm trying to get to the second stage. But they're gang officers, they're not traffic cops. These aren't stadies on the highway. I take it, I don't know what the record shows, I assume they're pulling over people they know a lot of the time. Not this time, but isn't that going to warp the statistics some? Because these are not blind stops, or they're stops of, again, a group of people they've gotten a list, right? I mean, the list may be wrong.
So that's, first of all, that's not this case, because in
Oh,
this
but it
case,
is,
but
isn't it
to your point.
Isn't it, say you win, and you've made a good case that the first stage is satisfied, and we remand this, because we've got to clarify what the second stage is. In the second stage, I assume the Commonwealth's going to say these are gang officers, so they're different from stadies, and they're different from those cases that we've been reading about in other states. And then we got to look at, you know, the neighborhoods where the different gangs in the neighborhoods and their makeup. I just, how do we do that? Because isn't that, again, if you win, isn't the next stage, stage 2, as Justice Gaziano says, we don't have very much guidance on how you're going to do stage 2.
I think to your point, again, it's not this case, because in this case, the officers did a CJIS query, and
Well, but they're not traffic cops.
right, and
For some reason, they thought this Mercedes in that neighborhood is indicative of something. I'm not sure that's justified,
that's the problem.
but I take it their statistics are more complicated than a state police officer pulling people over, because they're pulling people over because they're concerned about gang activity.
It raises an important point, which is that I'm not necessarily sure that it's explainable if they have a list comprised of Black and Hispanic people, and those are the people that they're targeting
Say
for
they're
minor
in-
motor vehicle
if they're in-
infractions.
I mean, it could be, say they're in a different neighborhood and there's a gang of X. That number is gonna, that may skew the statistics some, right? I mean, if you're, you know, I don't know, we have all different kinds of gangs. We have Cambodian gangs, we have different kinds of gangs. Isn't the number gonna be different? Isn't there gonna be, I'm not saying that the number is gonna be justified here. I'm just saying, isn't the statistical analysis is gonna be more complicated than a traffic stop on a state highway, isn't it?
So, I think the Commonwealth attempted to make that, some of those rebuttal points an argument, but conceded we don't have the data to back them up.
Okay, so that, but we have to give guidance on the second stage if you win. What kind of statistical how do you prove a statistical disparity, as you say? What kinds of factors? Because when you do the standard deviation analysis, you have to remove all the factors, and it's very complicated, at least in employment cases. I just don't, how's it going to work here when you've got these skewing factors out there?
So, I think I would go back to the original point, which is this is why law enforcement needs to keep track of all their traffic stops, because that would be the easiest way to rebut what this data shows.
If we lower the standard, or we make clear that the standard is not as impossible to prove, that if you put this type of statistical disparity, that satisfies prong 1. Prong 2, then the Commonwealth, if it wants to satisfy prong 2, is going to have to create much better data in order to show a statistical disparity that's justifiable.
I think that would be the best way to rebut it. Frankly, I don't exactly know. It's hard for me to know exactly what the Commonwealth would do in rebuttal, because I don't know what sort of justification they would have had for stopping and then citing 81% Black individuals. I don't know what that's going to look like.
Can I take us away from the statistics for a minute with modern technology? If I go through the Mass Pike without paying, I will get a notification in the mail and a bill. Now, we're talking about minor traffic violations, correct?
Correct.
Why can't those just be simple citations mailed to the automobile owner rather than a stop?
I don't see any issue with that. I hadn't thought of that. I think it makes quite a bit of sense and would alleviate some problems.
Mr. Warren, just on this case and your view about the rebuttal, and I want to ask you so that you have a chance to respond to what I think the DA's proposal is. But on your rebuttal point, you say, well, they didn't raise the issue as it relates to this case before the Superior Court judge, so there shouldn't be a remand.
Which issue? if I could.
The Laura statistics. They didn't come forward with statistics to rebut or
Right.
testimony to rebut. So as it relates to this case, you're saying that there should not be a remand, correct?
Right, I'm saying they had the opportunity
Yeah,
to
right.
do that.
Okay.
And
So from your perspective, this really complicated issue about what you do with the prong two, really, from your view, can't be remanded and addressed because they didn't raise it below. Is that right?
exactly, and they had Dr. Fowler's report 5 months prior to the hearing. It was an extensive report detailing essentially what she testified to. So they knew exactly what was going to be presented at the hearing and made the decision.
But why would they go to stage 2 if they won stage 1?
So, I mean, I think the answer to that is they need to be prepared to address both stages at the hearing. And there was no statement from the Commonwealth at the hearing to say, Judge, by the way, just to clarify, this is on stage 1, or before you make your decision, we want to make sure that we have the opportunity to rebut anything. They didn't present any evidence as to stage 2.
Can I ask just a more general question, which is, there are 2 amicus briefs here filed by the defense bar. I want to know whether you are embracing those. And of course, we have the brief by the Commonwealth, which also does not like Laura, apparently, and wants to supersede it. Do you agree with the Commonwealth's position? I want to know what your position is with respect to these positions, I suppose.
So, Laura was a step in the right direction. I think the standard, for the reasons I articulated, need to be clarified in the sense that a defendant can use available and relevant data and an appropriate benchmark. That would be the first step, and I think that would be another step in the right direction. To the extent the court wishes to change, add either another manner, an alternative manner in which a defendant can raise an equal protection claim, or go back and look at some of the cases that might have really be the core issue, Buckley and Santana here, that would be a bigger step in the correct direction. Whatever the court does, I think incentivizing law enforcement to track the data should be a focus.
So arguably, to do that, we could have a rule that said if you don't have enough data, that's your problem, that's the government's problem, not the defendant's.
Right, I think a defendant's job is to provide relevant and available data.
Can we just, you talked a little bit about it, but what did it take for you to get the statistics that you got? How, practically speaking, how does a defendant go about doing this? I just want to figure out, okay, you brought some statistics and they seem to be pretty good. How about the next person?
What we did was file, so for the FIOs, part of it was publicly available. So we obtained that. We did Rule 17s for additional FIOs and the citation data. Citations compiled by the Merit Rating Board. And then that was both the Rule 17 motions that were led by the court, and then sent that to the statistician who was tasked with organizing, compiling, and analyzing that data.
Chief, can I ask?
Sure.
So I just want to see if you could have a chance to respond to what I think the Commonwealth's argument is, because before you sit down, because I think if there was a remand in this case, or if they have the same proposal in another case, then what happens once you satisfy Laura, or actually in any way through testimony satisfy that there might have been an equal protection issue, I think what they're saying in the next prong is it gets subjective, and you look at discriminatory purpose, discriminatory result as well, actually. What's the effect of the discrimination along with the discriminatory purpose, and that it's equal protection so that it's subjective. And of course, we'll ask Ms. Campbell to flesh this out, but you're not going to be able to stand up again, so I'd love to know what you think about their proposal.
So first of all, I'm not entirely sure what their proposal is, because on the one hand, it simply restates what Laura says, almost verbatim, and then it says the court should adopt this new rule, and then at the end says, by the way, the court needs to look at subjective motivations of the police officers, which would completely undercut the Laura framework. I mean, if a police officer could testify and say, no, that wasn't my intention, and a defendant would have to introduce direct evidence as to an officer's subjective intent, that would be a complete departure from what Laura says. Laura says a defendant can meet its burden through statistics alone, and I would suggest that's what the Commonwealth has to rebut.
But I guess that we'll hear what the Commonwealth has to say, but it seems like we don't really have much information, even going back to Justice Graney's concurrences about exactly what rebut means.
I think the Soto case,
The New Jersey case is
the New
clear.
Jersey case
That's
describes
clear.
it very well.
Yeah, sure.
And I would ask this court to look at that language. And
Do you agree the remedy is dismissal and not suppression?
no, so I don't know where that's, I don't know where that's coming from. I don't think it makes a lot of sense. The harm here is the stop. So I think the suppression should be related to that, just as it is in the 4th, 5th, 6th Amendment.
But the case would be completely dismissed under
And
the
in
Commonwealth's
this-
analysis.
Right, and that's fine. That's
I bet
fine.
it is.
But the
But
amicus
but
don't think it's fine.
irrelevant, but
The
it's
amici-
irrelevant in this case.
But it is irrelevant in this case, but the amici don't think it's fine. They think they think it ups the ante and that it's so draconian that it's counterproductive.
It would, and I'm not sure if that's the point that the Commonwealth is trying to make, if the Commonwealth is trying to up the ante. But, so right, it would up the ante. I think doctrinally it doesn't make sense. It would lead to cases where the hypothetical I put in the footnote was we have a murder case. There's a minor piece of evidence seized from everyone agrees, a bad traffic stop. Murder case dismissed. I don't think, I think the suppression, it's related to what's happening. So it's not that I would agree that Mr. Long's case shouldn't be dismissed, but here it's a distinction without a difference, and I just don't think it makes a lot of sense. And at that, it could make a defendant's burden much, much harder, a burden that's been very difficult to achieve.
Now, you had said that we should say that a defendant may use available and relevant data to make the prima facie case, but you also said that the amount of available and relevant data today is less than it was when you brought your motion. What do we do if there's not available and relevant data? What if, say, Boston decides we're not going to keep racial information in our FIO?
So under the new law, my reading of it is that police departments as a whole will have their own data. And so I think the CPCS amicus brief makes the point that the court could strip the presumption of regularity in traffic stops with entire departments that the point that the amicus brief is strip the presumption of regularity with departments that have issues with racial profiling or where disparities are shown in that data. The other remedy would be remove the presumption of regularity where a police department declines to make this data available.
And by presumption of regularity, you would mean essentially you've satisfied your prima facie case with regard to a motor vehicle violation, and that suffices to essentially put the burden on the Commonwealth to show that it was race neutral.
Right.
Now, I have one last question for you, which is, what other states should we look to for guidance?
Not many, Judge. We have New Jersey, and that's
it?
about it.
That's it? New
That's about
Jersey?
it, as far as I can tell from my research,
Okay.
unfortunately.
Okay.
Wait, I'm sorry. So, I'm not sure I understood the answer to the chief's question. If there are no available statistics, so the defendant has nothing to present, what happens? What should happen?
So I think the court could go many directions, but I think either you put the burden on the Commonwealth to present evidence that it was race neutral, or the defendant has to make some limited showing, and this is addressed in the MacDill amicus brief, but some sort of variation on the would have test. So we strip the presumption of regularity, and a defendant says, look, these were gang unit officers, not typically traffic enforcement, and here are some other factors that happened in that case that, and again, a low bar because we've stripped the presumption that this is a regular traffic stop.
So you're saying you'd then go to the would-have test? Or you wouldn't have to go to the would-have test?
So I think there's two ways to do it, I guess. You could either, and you could put the burden on the Commonwealth, prove it's race neutral, or make the defendant make some minor showing as to this doesn't seem to be
'Cause I
typical
guess one of the
traffic
things I'm thinking about is that this is a systemic issue built into society. And so to defend any particular officer or accuse any particular officer, regardless of that officer's race or ethnicity, might be more difficult than one would want since it's a systemic problem. I'm wondering, do we need a more systemic solution?
right. And I think that would be looking at MacDill's answer for taking another look at Santana, which I know this court just did in Buckley, but another reexamination.
But remember, that was under a Fourth Amendment analysis. You would be
Right.
asking us to employ that under an equal protection analysis.
So I guess my first answer would be take another look at Santana and Buckley. The second would be how do we use some of the principles that the Washington and New Mexico courts have applied in the Fourth Amendment context under an equal protection where we have a gigantic issue. We don't have the data because the people who are in charge of recording the data aren't recording it, and we're left with no options. And the status quo, I think everyone agrees the status quo is not good enough.
Okay, thank you.
Thank you.
Ms. Campbell?
Good morning, I believe still. And may it please the court, Kaylin Campbell on behalf of the Commonwealth. To make it very simple, the Commonwealth, as it argued in its brief, believes that the Laura standard should change. And it's how exactly it should change that the court is tasked with figuring out today. In some of the questions that were posed, there were a lot of questions posed about how we incentivize police departments to actually collect this data, and that's why the Commonwealth proposed the change in remedy that it did.
Yeah, but I think the remedy, you skip the hard work and go right to the remedy.
We can talk about the hard work
Yeah,
first.
let's do the hard
Sure.
work first. Tell us whether or not you agree that the judge was wrong in his decision as to prong one, and then tell us what prong two looks like.
Sure. As to prong one, it's the district attorney's position that it should be remanded for application of the new standard, however it's articulated, because no one had the benefit of that at the motion hearing.
Was he wrong or not?
It was okay under the old standard?
Yes,
So
Yes.
he did not err.
correct. And I think when you look at the type of data that was presented, I disagree with my brother and I disagree with the amicus that FIO data standing alone is sufficient to meet the burden. And that's because it misunderstands what FIO field investigative observations are. And what I think is important when you look at a case like Laura, when you look at all these cases, is that there's a triggering event, right? Which is typically a traffic stop, which is undeniably a stop in the constitutional sense. When you look at an FIO, what they are compilations of all types of observations that aren't necessarily anything that would trigger any constitutional right. It might be that they saw you and I, Justice Gaziano, speaking on the street. There is no constitutional right that is triggered in that. So to lump that type of observation with a stop in the constitutional sense, with a frisk, with a traffic stop, I think is a good basis by which a judge could look at that data and say that's not the correct type of data that we should be looking at. Now, that's not to say that that type of data would never be relevant to this type of motion. I think that could be relevant both in determining whether the inference is raised and as to the step 2 analysis, which is you could look at an officer's pattern of sort of his interactions with individuals, how he patrols, and you could infer some sort of inference as to that.
But can't you say that and I think, I don't know where I read this, but that I think the FIOs are over something like a 7-year period, and there's something like 80% minority, if my memory's right. But
Correct.
And then, I can't remember where I read it, but that there's discrimination built into the FIOs as to who's FIO'd as well. So in other words, that it's an underrepresented number.
I don't know, I don't know if I agree with that assertion that
It's
there's
a-
discrimination built into the FIOs itself. Are you talking about the FIOs as used as statistics to support the defendant's first
No,
burden?
that the FIOs are overrepresented with people of color. That's the contention. I can't remember if it's the defendant's brief or the amicus brief, so it actually undervalues that number for the Laura purposes.
But
See my question?
I do understand your question, and I think that, but I think that when you're looking at sort of, again, to go back, if you're looking at sort of what type of data we should be looking at when determining what the data should be comprised of and what should it focus on, I think framing it in terms of was there a stop in the constitutional sense is sort of the cleanest, easiest way to look at it. And that's not to say that you can't consider that other data, but sort of the type of data that should be is sort of the stop in the constitutional sense, the stop of this car.
Yeah, and I know you're dealing with a different structure than Laura, and I hope you're going to answer Justice Gaziano's question about what prong 2 would look like.
Yes.
But I asked the question in terms of whether the Superior Court judge got it wrong that Laura was satisfied here.
And no is the answer to my question. But even if this court were to look at these statistics and find that Laura was satisfied, that's only stage 1. There was never any finding. If you look at the way that it is structured, there has to be that there is a finding that there is a reasonable inference, and then it then only then when there's that finding is the trigger that the Commonwealth has to rebut that inference. So I say, at best, we're asking for a remand to apply.
So you're saying that in every Laura-type case, there's to be 2 evidentiary hearings? One, we don't do that in discrimination cases. We don't do it anywhere else, that we have 2 evidentiary hearings, unless the judge says, I'm going to bifurcate the hearing and only decide the first issue. Was that done here?
That was not done here, but there was also no finding as to the first prong. So I'd say the Commonwealth was
But
never on.
since when do you get the privilege of the bifurcated evidentiary hearing to say we only will discuss prong 1 at this evidentiary hearing, we'll offer no evidence in the event you make the finding, and we reserve the right then to then come back and have a second evidentiary hearing?
I'd say the problem with any kind of question about how these hearings should go is that there haven't been many that have been successful, so there isn't any sort of guidance as to how they should go. I'd say looking at the standard itself would suggest that as to how the Commonwealth could present evidence. That's why, I mean, there's a lot of confusion generally as to how it happens, because you have sort of what happens is because it's largely the same witnesses, you have sort of, at least in my experience, the Commonwealth goes first as to the officer, but just on the Fourth Amendment issue, and so there's that type of testimony, and then the statistician either goes first or goes second, and it really is jumbled and confused as to the 2 different types of issues.
Let's assume we figured all that out.
Okay.
What would you have presented had you had the opportunity for the step 2 part?
Sure. And so as to this case, I don't want to talk in specifics because it isn't supported by the record, but I think it could be instructive as to sort of what a stage 2 hearing should look like. And I disagree with my brother that it only should be refuting the statistics, because if you look at equal protection claims generally, but I think the most instructive are the selective prosecution claims, what you're really looking for is a selective effect, a discriminatory effect with a discriminatory purpose. And I do assert in my brief, and I do believe the case law supports that the discriminatory purpose is subjective. I think an easy way to think about this is almost to analogize this to a Batson claim, in which, you know, there's numbers that you can point to. In that instance, it's the striking of jurors to see if there's a pattern, and then it switches to the prosecutor to state the race-neutral reason why they exercise that challenge. I think a similar type of sort of analogous analysis could work and should work in this instance.
How does that help the harm if say this played out, right? And the stats are what they are in this case, and then collapsed here, and police officers get back on the stand and they say, we really are telling you, Judge, we didn't stop the person because they were black.
Well,
And the judge says, good for me, and it's over?
no, I think there has to be more and a more.
That's a race neutral. We stopped
That
it
is-
because we ran the inspection sticker. The inspection sticker was invalid. We pull everybody over that has invalid inspection sticker. That's similar to what happens in bats and sores.
Sure.
It's a race neutral reason, but how does that help the systemic harm that Laura's trying to combat?
I think my answer to that is twofold. I think looking at the statistics and the broader statistics of sort of a pattern of behavior of any kind of officer would inform the credibility determination that a judge hearing any officer saying that would make. The second is I don't think that you can just point at statistics when you think, and this case shows why, as to sort of what officers are tasked with investigating and the type of units that they're tasked with being in. So for example, if you have an officer who is part of the Youth Violence Strike Force in Boston and is tasked with investigating Cape Verdean gang violence, then of course the statistics as to his FIOs are going to look very different than the statistics of someone who's just on a routine traffic patrol or someone who is tasked with investigating crime in Chinatown. The specific sort of investigatory tasks that these officers are given have to be taken into account when looking at the statistics that are presented. And that's important. Again, I don't want to bring it back to this sort of triggering event and what should the focus be, but there's no constitutional right not to be investigated. And so there has to be a balance against police officers' valid right to investigate crimes, often serious crimes of violence, against individual rights of people and recognizing the systemic problems of racism in society. And that's almost an impossible balance, I recognize that.
Aren't we talking, I thought we weren't talking about investigating crimes, that we were talking about basic minor traffic violations.
Sure, but I think if you look at, so if you were to use the benchmark of FIOs, for example, that's investigatory, that's investigating crime. So to point at FIOs and say, you know, they stop 80% of people of color that they look at, that's not really a true picture of sort of the discriminatory intent or purpose of the interactions that this officer had with an individual. So I agree with you. That's where I think the data is important and what data that you look at is important.
Can you think of any way to address the systemic harm without putting the weight on the individuals involved in it in this instance?
Without putting it on
The
the
weight
defendant.
on the individual police officer or the weight on the individual defendant? Because it is a broader systemic issue, isn't it?
Correct.
So how do
Correct.
we remedy that with little individual remedies?
I think in the same way, and again, not to bring it back to Batson, but Batson also recognizes that there's sort of, I can't say this word, systemic problems of racism in jury selection, right? And so the way that they do that is create a burden for a defendant, which is initially low, and then to shift that burden to the prosecutor to state the reasons why this would be a valid exercise of power, exercise of a peremptory.
But you seem to agree that right now we have Laura, which is, and that first prong is so difficult because, I mean, just look what it took in New Jersey on the New Jersey Turnpike to the man hours.
Correct.
So it's too much. I mean, even this case was a lot of legwork over 7 years or something like that.
Correct.
So it seems like you're agreeing that first prong shouldn't, just like in Batson, I guess you're saying, shouldn't be very weighty. What should it be?
No, and I think it should.
What should it be?
What should it be, or what shouldn't it be?
No, what should it be? What do you need to? If Lawrence just too much, which I think you're saying, then what do you need to be able to show to get to this Commonwealth do prong two?
The answer to that, I think, is the problem that I could identify with the Laura standard was that similarly situated. That the defendant would have to point to someone who is similarly situated. And Laura, and this is at page 438, it was described as credible evidence that persons similarly situated to himself have been deliberately or consistently not prosecuted because of their race.
How do you show the people who weren't stopped?
Absolutely, I agree with you. So I say that's the problem because you're asking the defendant to prove a negative as opposed to point to evidence which shows a positive. And so the Commonwealth's proposition is that the change in that first prong is really the change away from the negative, which is similarly situated persons, to the positive, which is using data and seeing if there's a statistically significant, anything about sort of the stops as they compare to.
And do you agree that if the particular department is not keeping or sharing the data, that should inure to the detriment as to prong one?
Yeah, that's a difficult question, and you know, the Commonwealth, I think, wishes that there was more data available as
I'm
as
getting
well.
totally confused at this point because I don't understand because we got traffic stops, we got units and traffic stops. So this is a gang unit doing traffic stops, but it's not, has no intention of giving traffic citations. So and then you're telling us we should look at the traffic stops maybe, but not the FIOs. But that's the data we got. So how do we do, I mean, is this give us a little practical guidance here. So
Sure.
he got two masses of information, FIOs and traffic stops.
Yes.
And both of them have apparent disparities, particularly the FIOs. Now, I understand it's a gang unit, but are we allowed to, has he done his job on those two things? Because he can't do any better, given what he's been given.
I would say no. And so as to the FIOs, no, because
He can't do any better, or know what?
Who's he?
Yeah.
he is defendant. As to the two categories of that information, as to the FIOs, the problem is when you look at the expert's report, she lumps all the FIOs together. So she doesn't segregate out the FIOs that were a traffic stop as opposed to FIOs that were observations. So I'd say that, and she made assumptions that an FIO was conducted in every single traffic stop, which there was evidence to support that that wasn't true. So I'd say that's a problem with methodology that the expert used to make conclusions based on the statistics.
He has to evaluate, the defendant has a problem, which is they're pulling over people in minority communities at a much higher rate. Why they're doing it is, you know, the cops are doing, especially the gang unit, is not in traffic patrol. They're using these as excuses for FIOs, right?
I disagree with that.
Okay, well, then why are they pulling over this? Why are they pulling over this car?
Well, I disagree that an officer that witnesses a traffic violation necessarily has to be assigned to a traffic stop to be able to pull that car over.
I thought one of the two officers pulled over 1,000 people and gave 5 traffic citations, some astronomical number indicating he's not doing traffic patrol, right?
Sure,
So
sure.
what do we do with that? Take that example. Say that's all he presented. Is
Say
that
that's all-
enough to meet stage 1? When it's 80% of the people? It just seems like a compelling number that we should be analyzing. Because I mean, I don't know a lot about statistics, but that is a really big number.
Sure, and I would say that pointing to those statistics, a judge could find that. A judge could find that. That doesn't mean that a judge necessarily has to find that. And I think that's where the difference lies in sort of the Commonwealth's articulation as to the LORA standard, the new LORA standard that it says this court should adopt, and the current LORA standard.
What is the new, I mean, the lower standard made perfect sense at the time. It was a time in which people were recognizing the importance of maintaining data to deal with racial profiling, and it was written with the expectation that we were going to have data on traffic stops based on race so that we could do the analysis in LORA. And that turns out that to not be true.
Correct.
So we have one alternative, which is what the defendant argues, which is the defendant has to play the cards that they're dealt, and we have to be essentially quite forgiving in terms of when it meets the prima facie case, because we don't have the best available data. Do you agree with that?
Yes, and not to qualify it, but yes, insofar that that could be enough to meet the standard.
Okay.
That doesn't necessarily mean that a motion judge would have to find that. that meets the standard.
And why is you've discussed the FIO, why is the motor vehicle citation data here not enough here?
I think the motor vehicle citation is not enough here. If you look at the judge's findings, He found that with respect to Dorchester itself, Dr. Fowler found that 19 of the 38 citations, or 50%, were issued to black drivers, and that the racial composition of Dorchester is 46.31% black per census data. After running the Z-test on this data, Dr. Fowler found that the resulting p-value does not cast doubt on the assumption of no racial profiling. So I'd say that there was a finding from the judge that the expert's own analysis of the statistics as compared to African-American drivers who were stopped as compared to this neighborhood in Dorchester doesn't support.
Different in Roxbury, I believe. There was
It was different in
a
Roxbury.
finding that it was statistically significant with regard to Roxbury.
Correct.
Okay, so you're saying this is not enough here, even though we have a considerable effort on the part of an able defense lawyer and an able statistician to attempt to do the best they can with the data they have.
Under the old Laura standard, yes,
Okay,
it's not
so,
enough here.
so you said the old Laura standard ain't going to work because even when you have an able attorney and an able statistician, given the quality of the data, it's not going to be enough. So but you also recognize that there is a reasonable concern about selective enforcement through racial profiling, correct?
Absolutely.
Okay, so give us the new prima facie test.
Sure. The new prima facie test is, and this is what I wrote in my brief, credible showing that either those similarly situated were not stopped. So that's like New Jersey where they count the cars. You could do it that way.
But you can't, I mean, you're gonna, I mean,
No, I mean,
how are we gonna, I mean, the defense bar can barely pay for investigation. They're gonna hire people to be counting cars on city streets?
I'm not disagreeing with you there.
And come on, I mean,
No.
don't give us a formula which you know is impracticable.
I don't believe that. I think I'm giving a formula that recognizes that is one avenue, however impracticable, that someone could choose to take, especially with the advent of new technology where there are some cases, the federal cases, where they talk about setting up cameras and counting based on the cameras that are set up. So that's sent.
You want the defense counsel to have access to all of the cameras that a police force has so they can gather all that data as part of a defense?
I am putting it forth simply as an avenue by which a defendant could try to meet it, to not
Okay.
foreclose
Give us one that a
and-
defense lawyer with reasonable means and reasonable ability can pragmatically meet,
Sure. And
where there is, in fact, racial profiling.
Sure. And the second is looking at, I don't disagree with my brother that looking at what is available, so long as what is available accounts for the correct type of data. So, you know, my argument sort of depends on what police officers collect. I think there's a problem with the new passage of the law that doesn't necessitate the notation of race, but I think in this instance, looking at the merit rating board, looking at who stopped, I don't think that it necessarily has to be indicative of everyone that was stopped, but looking at that data and at those stops and saying, is there a difference between, is there a higher number or a statistically significant number of people of color who are stopped as opposed to people that are not of color?
So are you saying that if the data reflects that Boston or Brockton or Lynn, or for that matter, Wellesley or Lexington, indicates that there's racial disparity in terms of a stop, that suffices for all cases by those police officers to meet the prima facie case and shifts the burden to the prosecutor to show that it was race neutral?
Are you saying that, I'm sorry, I just don't understand the question. Are you saying?
Let's assume, for the sake of argument, okay, that data, when it's generated, shows that there are various jurisdictions with substantial racial disparity among who is stopped, and that the racial disparity indicates that African Americans are considerably more likely to be stopped, given their percentage of the population, than white persons. Your brother says, well, that means then, with regard to every case involving a police officer from that jurisdiction, that should suffice to meet the prima facie case of racial profiling or of selective enforcement, and that should shift the burden to the Commonwealth to prove that this was a race-neutral stop.
So generally, a town engaging in racial profiling means that sort of a presumption.
If it's Wellesley, it's a Wellesley police officer making a motor vehicle stop, which results in a non-motor vehicle prosecution, then that would suffice.
Under the current data that's under
Under the new state law?
under the new state law, absent, if it really is true that they aren't collecting it individually by officer and it's that problem, then yes, I could see how that could be a workable solution. I would caution against that insofar as we don't know how actually that's going to shake out. We don't know if it is in fact true. We don't know what the sort of citations look like. I don't know how that information wouldn't be collected by merit of the way that traffic citations are issued. So that's what gives me pause in that answer, but hypothetically, assuming that there is no universe in which you can reasonably figure out which officers issued which citations, then yes.
The MACDO brief offers an alternative, which is if there is a showing that it is a pretextual stop, that is that the true purpose for the motor vehicle stop was not to make a motor vehicle citation, but in fact to attempt to do a criminal investigation, that there essentially was a stop and frisk policy with regard to automobiles, that would suffice to meet the prima facie case. Do you agree with that?
No, I don't. I don't agree with that. And I disagree with that insofar as though it doesn't explicitly, what it really does is switches the presumption that traffic stops are undertaken in good faith.
Well, but maybe it's time to do that.
I don't believe that. I don't believe that you should. I understand that that is something that the court could do. I caution against that insofar as that presumption exists because it asks the court to exercise a judicial power over a special province of the executive, and where it touches on separation of powers, I strongly urge the court not to do so. But I do fully understand that is something the court could do.
What about the idea of always making this be by citation as opposed to by stopping?
I hadn't thought about that until
Good, huh?
You guys are good. I disagree with that insofar as there's certain sort of motor vehicle infractions that could impinge on the safety of the road, and I wouldn't want.
Might be different than some other kind of motor vehicle citations.
Sure, just blanket when you see a motor vehicle citation.
Minor motor vehicle transit that would only be subject to fines,
Broken tail light.
fog lines.
Understanding that, it gives me. That gives me pause too because of potential public safety violations.
So, I mean, what do we do? I mean, you say this infringes. We have an officer here who says that he made hundreds of traffic stops every year and gave only a handful of traffic citations. So we know that when he's making those stops, in the vast majority of cases, he's not doing it to give a motor vehicle citation, or his evaluation of whether there's probable cause or reasonable suspicion that there is a motor vehicle citation is terribly poor. So let's assume it's the first. Is that within a law enforcement prerogative to essentially say that if we have reasonable suspicion to believe or probable cause to believe there's a motor vehicle citation, and that's not our intent, but our intent is to stop the car, give us an opportunity to see if there's an outstanding warrant, see if the person looks nervous and if we can find guns or drugs, see if something happens to justify the impoundment of the vehicle and therefore do an inventory search and maybe find drugs or guns, that is something which is permissible for police to do, and that we as a judiciary should not in any way prevent that or have any, or it's not within our judicial power to take any steps with regard to that.
I think you could. I think you could take steps in saying that that type of showing could result in a finding by a judge of the first prong. But I don't think you want to create a rule by which an officer has to issue a citation every time they pull someone over for a minor motor vehicle infraction. That's mostly as a driver in this Commonwealth.
But when I presented the possibility that a showing of pretext would suffice, you said, no, we can't do that. And I'm trying to figure out why we can't do that.
No, you asked me if I thought that was a standard that you should adopt. No, that's not the Commonwealth's position that that's the standard you should adopt. Because what gives me pause there is sort of the definition and meaning of pretextual. And what gives me pause there is, and especially am glad that we ended up here because I wanted to respond to my brother's, what he ended on, which was asking the court to revisit Buckley and Santana. There really does exist under the Fourth Amendment a separate and apart remedy for Fourth Amendment violations as to where there isn't an objective basis for the stop. And this, even, you know, the equal protection claim and violation here is really, it should stand separate because it recognizes that even where there's an objective basis for these types of stops, there could be an improper motivation for those stops. And so to mix the two together, I just don't think that analytically really serves anybody's best purpose where there are these two different remedies.
I'm sorry, but why does it mix it together if we say Buckley was a Fourth Amendment case, and we're not going to say that pretext matters for a Fourth Amendment claim, but it might matter with regard to an equal protection claim?
And I guess I don't understand what you mean by pretext. Is there a finding that there...
Finding that the true reason for the motor vehicle stop was not the motor vehicle violation, but it was an excuse to do all the things that can happen when you stop somebody. The same motivation that was found in New York with regard to stop and frisk policy is all the things that can happen when you stop a vehicle and interact with the individual, and the potentials for the arrest on an outstanding warrant, the possibility of an inventory, of an impoundment and inventory search. I think you know what goes on the street.
I don't know, I agree. Well, I understand the question that you're asking, and I would say sort of what you're touching upon is more of a second pronged discriminatory effect and a discriminatory intent. So if the intent of the officer was not necessarily to do a traffic stop, if the intent of the officer was to do something else, that surely is something that could be considered at that second stage. So I don't think that it necessarily never comes into play at all. And a defendant surely could argue that, but I think in the framework that the Commonwealth has presented, that there is room for that evidence to come forth and for the judge to consider
But the first stage can't be very high then. That's why I don't understand if you had these facts, when you have a police officer who, over the course of years, has given so few traffic citations for minor motor vehicle infractions, why that shouldn't get you to that second question.
And it could, and I think that's where sort of re-articulating and explaining what is in that first prong is what the court should do. Now, that doesn't necessarily mean that a judge has to credit that or a judge has to find that. And that's why I caution that the real reason why the Commonwealth is advocating, well, not the real reason, but a reason that the Commonwealth is advocating for a remand in this case is because none of this was clear when the evidence was being presented to the judge because of the lack of any type of case law on this type of this issue. So it wasn't really clear what could suffice for the first prong, and it never has really been discussed what should be considered at the second prong. So it seems in the interest of justice to sort of let everybody with guidance.
But the remand's interest of justice in this particular case, you could have rebutted the Laura evidence. It doesn't seem fair. I mean, it might be the next case, but in this case, for this defendant, it doesn't seem fair to remand it because it could have been, the rebuttal could have been presented at this motion to
So my response is twofold. The first is I don't think that was clear first based on the Laura standard that the Commonwealth had an obligation to do so at the hearing. But the second is if you're looking at what was before the judge and what the judge found and whether that would be sufficient to rebut the presumption, I would point to the officer's specific crediting, the judge's specific crediting of the officers that they didn't know the race of the individuals at the time they decided to run the license plate through CJIS.
May I ask you one? I understand that in some circumstances there's difficulty for defendants just getting a Laura hearing. What should be the threshold to trigger the Laura hearing itself?
So I think similar to a motion for new trial, if you look at sort of the papers that are presented and ask whether it raises, I forget, sufficiently credible.
Substantial issue or something?
Substantial issue. I think it should be similar to that motion for new trial standard.
We still have the impoundment issue, which I don't want to dwell on, but the Boston Police Department policy, at least as articulated in the brief, I've not gone back to look at the policy, apparently says that securing a car, even if you don't tow it, requires an inventory search. First of all, does the policy say that?
If you have to go into the car, yes.
But why would you have to go into the car if you're merely securing it? If you're merely basically say we're going to lock it and park it on the street?
It depends on, there could be an instance where you have to go get the keys or you have to go get valuables out. It's meant to protect the Boston Police Department from claims of theft insofar as they entered the car.
So you're saying every time they enter a car for a protective search, they are entitled to do an inventory search? Every time a police officer enters a car for any reason, even for a protective sweep, they're permitted to do an inventory search?
I guess typically, if they're going to tow it, yes.
Leave it.
Or leave it.
What if they decide they're going to just going to lock it and don't leave it to be on the street?
If they have to actually go inside the car to take the keys to lock it, then yes, to present themselves from the risk that a defendant would say, I had X amount of property in the car and it wasn't there when I returned.
That does give an incentive for police to find a reason to go inside the car, because then they would get an inventory search under your theory.
Yes, but I think that can be resolved by looking at the specific facts of the stop and what was necessary to secure it. If the court has no further questions, the Commonwealth will rest on its brief.
Okay, thank you.
All right.